Thank you, Leo. Good morning, everyone. Good evening for our wonderful speakers who are on the other side of the world. Thank you so much for being here with us. I'm pleased to welcome you all to the third session of ICC Brasil webinar series on servicification and manufacturing for export, custom regimes and services inputs. As most of you know, our first events covered the Americas and BRICS countries. This today will cover the experience of Asia. The previous two webinars are available on our YouTube channel in case you want to rewatch them. So why did ICC decide to put together this series? This is an exploratory series due to the diagnosis that, at least in Brazil, traditional customs regimes fall short of reflecting the characteristics of today's services economy. It is well known that services represent the larger part of the global GDP. There is growing consensus that services linked to exported goods are a key factor for the competitiveness of goods exports. In Brazil, for instance, goods exports contributed more in services value added to the economy than direct services exports. Despite the importance of services as a proportion of good exports, the Brazilian regime for processing goods for export, which is called the drawback regime, does not exempt or suspend any taxes or fees on services inputs for exported goods. So today there are two main questions that we will try to answer in our conversation. One is, to what extent do current custom policies, in particular drawback regimes or inward processing regimes, cover services inputs to exported goods and services linked to the export of goods? And the second one is, to the extent that custom policies discriminate services inputs compared to physical goods inputs, should they be adapted in light of servicification trends? This session will address these questions based on the examination of the customs and tax policies of China, Indonesia, and Singapore. This conversation will be moderated by Luiz Eduardo Salles, who is the Executive Secretary from our Trade Policies Commission and a partner at Azevedo Sette law firm. Luiz, over to you, and I wish you all a wonderful conversation. Thank you.
Thank you again, Gabriella. Welcome everyone at the audience and our speakers. Good evening, Asia. Good morning, Brazil, right? So thank you all very much for being with us that late for you in Asia. And for us, it's not that early. So in any event, thank you everyone for attending. My role here is really to introduce you and then ask you the questions. As Gabriella put it very well, our concern at the ICC is that the Brazilian customs and tax regimes lead to an accumulation of taxes on services that are embedded in the cost and price of the goods exported by Brazil. So we are gathering experts from different countries to explain how that situation takes place in their respective countries. And this has been very insightful so far. We're very excited to have you here. We have representatives from Asia, as Gabriella mentioned this morning, and we will learn the lessons and experience of the regimes of China, Indonesia, and Singapore. Let me introduce you the speakers from Indonesia. We have two speakers today. On one hand, we have Ira Eddymurthy, who's a founding partner at SSEK Legal Consultants. She has more than 3 decades of experience advising multinationals and domestic companies on Indonesia's regulatory environment. Ira is recognized as one of Indonesia's top banking, capital markets, and M&A lawyers by leading legal directories. She graduated from the University of Indonesia Faculty of Law in 1984, was a visiting scholar at the University of California, Berkeley School of Law, and attended the Academy of American and International Law in Dallas, Texas. She's a member of the International Bar Association and the Inter-Pacific Bar Association, and represented Indonesia at the IPBA from 2002 to 2008. She's an acting chairwoman of the Commercial Law and Practice Commission of the ICC Indonesia. So Ira is home today. Thank you, Ira, for joining us. Next to Ira, representing Indonesia, we have Fransiscus Rodyanto, who's also a partner at SSEK. His practice is focused on energy, including renewables, mining, oil and gas law, M&A, foreign investment, and general corporate matters. He obtained dual bachelor's degrees in law and economics, and he also has a master's degree from Leiden University in the Netherlands as part of the Leiden's University Excellence Scholarship Program. Then from Singapore, we have Lan Yu, who's a member of Duane, Morris, Selvam, China's practice group. She specializes in corporate and commercial law, advising listed and private companies and ultra high net worth individuals on mergers and acquisitions, joint ventures, corporate governance, foreign direct investment projects and partnership. Her practice areas also include employment law, data protection, and regulatory compliance. She is a regular speaker for China-related seminars, a graduate of Columbia Law School in New York and Peking University Law School. She is qualified in the People's Republic of China, England and Wales, as well as New York State, and registered as a foreign lawyer in Singapore. Lan Yu, I think then is a whole webinar of her own with a bunch of qualifications, and the committee member of Singapore China Friendship Association and Peking University Singapore Alumni Association. Then from China, we have Menghao, Senior Associate at King & Wood Mallesons, Shanghai. Mr. Dai is a senior associate of KWM's Customs and Trade Compliance team. And prior to joining the firm, he served in PwC's World Trade Management Service team and a reputable China law firm for more than 8 years. He obtained his master's degree in Juris Masters from Fudan University in 2011, and was originally graduated in Illumination Engineering from Fudan University in 2007. He's a practicing lawyer in the People's Republic of China, and he also obtained the PRC patent bar. His working languages are Mandarin and English. So having introduced the speakers, we are ready to start and ready to ask our first question. We will begin with Indonesia, France, then Singapore and China for this first question. And the question is, what are the main customs regimes covering manufacturing for exports in each of your countries? So France, if you would please start introducing the Indonesia regimes, please. Thank you.
Thank you, Luiz. First, I want to thank you, ICC Brasil, Luiz, Gabriella, Leonardo, for giving us SSEK the opportunity to participate in this webinar. Thank you very much. Hopefully we can enlighten the custom regime in Indonesia, specifically with respect to the services in relations to the manufacturing of goods for export purposes. So before I start to the custom regime, I think I need to share with you all with respect to the general information regarding export and import in Indonesia. So basically, Indonesia is still considered as an importing country, This is because of, based on the data between 2015 and 2019 last year, basically import experienced a 7.2% increase, while export is only 4.4% increase. Now, in 2019 alone, last year, the total import amounted to 171 billion, and for export is only around 167 billion. This shows that actually Indonesia is still an importing country rather than an exporting country. But with despite of that, basically now we go to the custom regime in Indonesia. So basically, if you are exporting particularly goods, export duty, you will be charged with export duty and export VAT, value added tax. The export duty is between 0% to 25%. And this is imposed to export mainly on leather and woods products, cacao beans, crude palm oil products, metal minerals and its derivatives, including all products resulting from the processing of metal minerals. And for the export of VAT, basically for export of goods, it is 0%. But for services, which will be elaborated by my senior partner, Ms. Ira Eddymurthy, it will be between 0% or 10%. Now, with respect to the import, there are several charges being imposed by the government, by the Indonesian government. Basically, there are three: import duty of up to 150%, import VAT, which is typically 10%, and income tax on imports. There are two rates for this income tax on imports, 2.5% if you have an import identification number from the relevant government institution here. But if you don't have that importer identification number, you will be charged with 7.5%. For certain products, it can go up to 10% even. Besides those three charges, there are also luxury goods sales tax, which can go up to 200%, but currently under the regulations, it is charged around 10% to 125%. And for import of alcohol and tobacco products, there will be also charges on excise. Now, despite, with respect to these various charges on import, the Indonesian government provides several facilities on imports. The most relevant one for us is actually called the ease of imports for export purposes, or commonly known as inward processing in European countries, or export processing, I think, in China. And the facilities here are, you can be exempted, or there is a drawback facility for import duty of goods, capital goods and raw materials. There's also applicability of non-collections of import VAT, as well as luxury goods sales tax. In order to obtain this facility, companies need to obtain what is called as the company master number from the custom office. The main requirements to get this company master number is actually the company needs to have a computerized inventory system that manage the goods, and it should be linked to the customs documents and accessible by the custom office. The company must also need to have evidence of ownership and possessions of a locations for its production activities, raw material stockpiling, as well as production output stockpiling. The other requirement is that the company needs to have, I think this is general, to have a clear production plan with production flow, importation and exportation plans, list of raw materials, list of production output, and so on. The other facilities being given by the government is called the master list facilities or master list regime. This basically provided for Indonesian companies to have an exemption of import duties of goods and materials. Now you need to obtain this facility to the Indonesian Investment Coordinating Board. The other regime is basically called as the spatial designated zone. We have various zoning in Indonesia. More or less, in general, we can classify 4 zoning. The first one is the industrial estate. The second one is the free trade zone, special economic zone, and bonded zone. So if you have companies in these locations, so you can actually eligible to obtain facilities for exemption of import duty, exemption of import VAT, non-collections of income tax on imports, as well as the 2 other that I just explained on luxury goods sales tax and excise. The next one is there is also a regime where companies can benefit from the free trade agreement that Indonesia entered into. Right now, Indonesia has entered into a multilateral agreement with the Asian countries. This is the Associations of Southeast Asian Nations, and it can provide a facility to reduce the import duties of most goods to 0%. And we also have a bilateral free trade agreement with China, Korea, India, Australia, New Zealand, Japan, Pakistan, Chile, and Palestine. Aside from the facilities with respect to reductions of the customs or import charges, I need to share with you all as well that basically to promote investors, to encourage investors to come to Indonesia and put their investment in Indonesia, the government of Indonesia also provides various investment incentives. The ones that I will present or share with you in this webinar is 2 actually. The first one is the tax holiday. So basically under the tax holiday, companies can benefit to have a reduction or even a 0% income tax. So now, generally speaking, the income tax in Indonesia for a company is at the rate of 25%. So if you have a tax holiday, you are eligible for this tax holiday, then you are granted for a tax reductions of 50% or even 100% for the durations of 5 to 20 years, starting from your commercial productions. And depending on your investment value, whether you will get the 50% for 5 years or 100% for 20 years. The government set up or determine the business sectors that are eligible for these tax holidays. Normally, for example, is petrochemical industries, electronic main components manufacturing, manufacturing of vehicles like trucks, cars, or motorcycles, including its engines and main components, and many others. This tax holiday is granted for specific industries, which normally companies engaging in pioneer industries, introduce new technologies, and have strategic value for the national economy. Now, the other tax incentives from the Indonesian government is called the tax allowance. It consists of 4 incentives. The first one is the reductions in net income of up to 30% of the amount invested, which will be prorated at 5% for the durations of 6% of the commercial production. It can go as high as 60% if the company at least employ 300 local manpower and the business that the company engaged is basically falls under the business sectors determined by the government that's eligible for this tax allowance. The second incentive is the accelerated depreciations and amortizations reductions. And the third is extension of tax losses carry forward for up to 10 years. And the final one is the reductions of the withholding tax on dividends paid to non-residents to 10% or lower if Indonesia have a treaty relief with other countries with the origin of the investors, the shareholders. Well, normally the dividends for non-residents is basically set at 25%. So with this tax allowance, it gives more economical benefit for investors for sure. This tax allowance is also given for business sector determined by the government. A lot of business sectors actually. This covers the shoes industries, pharmaceutical, computer-related manufacturing, and others. Yeah, the companies need to have high investment value, and its product is for export purposes. It also needs to have high absorption of local manpower, and as well as high local content. I think that's it for the general idea of how the custom regimes and the incentives on tax in Indonesia that I can share with you, Luiz. Thank you.
Thank you so much, Franz, for your insight and general explanation. Just one question that we may discuss at the end, which I found interesting. You mentioned that there is an income tax on imports. So since I was unfamiliar with that situation, we can address that at the end of our session after we close this, because I haven't heard this yet from the countries that have spoken in this webinar series yet. Sure, thank you very much again. Now on to Singapore. So Lan, if you could explain us or provide us a general description of the main customs regimes in Singapore, we would be grateful. Thank you. Thank you again for joining.
Thank you very much. Thank you, ICC Brazil, and thank you, Luiz, for inviting me.
Lan, I think your mic is muted. Can you check, please? When you started, we could hear you, but now we can't. Not yet. Let me suggest something. Why don't we hear from Mr. Dai from China, and then we move on to you, and meanwhile we can try to fix the microphone issue. Mr. Dai, can you hear us?
Sure. Okay, Luiz. Yeah. So it's my turn. Yeah, right. So as now as the workshop of the world, China maybe have a long history for its we call it export-oriented industries. Maybe since the 2079. And for the introductions of the customs regions or the jurisdictions of the China supervisions on import and export, maybe I think I could introduce it, maybe divided maybe to the following parts. And the first part, maybe we could have a first introductions about the major customs supervision regimes in China. For a long history, that the China maybe the customs the supervision regions, or we call it the customs district, maybe very localized and will be subject to the different province, and maybe they have different policies. However, after 2015, the China has a very deep reforms on the customs structuring, and they restructuring the customs maybe from the two sides. The first issue that somebody may know that in the past that in China the customs maybe just focus on maybe the duty collections, and they may not focus on the other duties. For example, the import and export goods inspections, and the obligations for the import and the export goods inspections was in charge of by another authorities we call the AQSIQs. However, after 2018, that the two authorities are combined to one, the new China Customs, we call it the GAC. Yeah, and the other issue that from 2000 and I think it's 2016, the China has maybe introduced a new concept, like maybe like the CBPs in the United States, that we have a centralized center, maybe we will be located in, for example, in Beijing and Shanghai and Guangzhou. Maybe they will focus on different chapters of the goods, and all of the import goods will be supervised by chapters by the different centers, and instead of by just the local customs subject to their local practice. And that means that after the reform in China, they will have a unified standards for all the entries of the products. And since now that we believe that the new systems for the customs reform will have maybe a significant effect in 2016, that things, as we may know, that the most, for example, the inspection, customs audits and customs inspections are maybe followed by the instructions maybe from the two, maybe the three new organizations we call the customs duty collection center, the bureau centers, and they will maybe instruct the local customs to make a centralized the management on the local customs issues. And the second issues maybe we could discuss about maybe the duty duty rates of the China. And in 2019, per the feedback from the China Customs, the average duty rate in China is about maybe around 7.8%. It's maybe a bit maybe relevantly higher than the other countries like the United States. But China are taking efforts maybe to eliminate the barriers of the duties. And for example, the China now maybe entered several free trade agreements with other countries. The most important FTAs for China, maybe the first is maybe with the Asians, that include the most Southeast Asia countries, and the FTA between China and Korea, and also the China is maybe taking effort to proceed the signing of the RCEP, a new FTA that may be very important and have a great milestones we know in the last years. And under the FTA, that the most duties for the imports in China that will be decreased to about 0% to around 5% at that level. But in China, they will have a unique systems for the export-oriented industries. That is, if we import the goods and after the manufacturing, and then it will be export to overseas, we could leverage a special business mode we call a processing trade. Under the processing trade, even though the goods are maybe origin that from the countries not enter the FTA with China, even from the United States, we also know that China imposed relative high regulatory duties on such goods. We could still make the goods under a bonded status. That means after the entry of the China, they will have no need to pay the duty first. And after the goods export from the China, we should duty the exporters don't have the obligations or to pay the duties anymore. But the bounded goods in the China will be under strict supervision by the customs, and normally it will be registered in a special handbook in China customs, and the China customs will supervise the consumptions of the bounded goods to ensure that all the goods shall be exported to overseas totally. If after the customs inspections that the goods may be, for example, maybe are not inconsistent with the customs record for the export of the raw materials, by calculating or checking the finished goods, the customs may impose additional to claw back the duties and maybe impose additional penalties on the companies, and that will be very high tax exposures for most exporters. Yeah, and for this issue, that the other maybe things that somebody may be concerned or maybe interested in is that the VAT refund for the export. For the general trade, that we know that the goods are not maybe exported under we call it the processing trade mode. All the export goods could enjoy totally a complete VAT refund rate, and after the VAT reform since 2018, currently the VAT refund rate in China in most likely is around 13%. However, for the processing trade goods, even though it will be exported to the overseas, unfortunately, most of them may not could enjoy a complete VAT refund rate. For the processing trade goods, it will be divided maybe for the two modes, depending on whether the raw materials are provided by the by the outsourcers in overseas, whether it is free or maybe it was purchased by the exporters independently. If the raw materials are provided by the outsourcers in the overseas free, in this circumstance that the exporters may not enjoy any VAT refund. And for the for the raw materials that are purchased by the exporters independently, that under the processing trade mode, we will call it contract manufacturing. The VAT refund rate will be the total value of the export goods to deduct the import raw materials value, and then we could enjoy maybe, for example, a 13% VAT refund rate, something like that. And currently, compared with the general trade mode for the most in most circumstances, that the processing trade don't have such an advantage for the exporters. The main issue is that the first thing is that maybe like just maybe we mentioned before, is that the VAT refund rate is not as higher as the normal general trade. But the second issue is that the bounded goods, the raw materials, are maybe under a more strict supervision by the customs, and always maybe trigger the additional customs audit on the handbook and the bounded raw material management. And the third issue is that since under the processing trade mode, that all the goods have to be sold to the overseas, sold to overseas, and such goods may not be sold to domestic market until they may be paid additional duties for the raw materials. So it will be a very huge advantage for the exporters, maybe to select the maybe appropriate business mode for them. And yeah, and I think for the most we call it the customs regions on the manufacturing and for export, maybe for China, maybe mostly I think the main issue I think for China is like that. Okay.
Thank you very much. If I got your message very clearly, it doesn't look like compared to the general trade regime in China, the processing trade regime is particularly attractive from a general perspective. So it means that in comparison, right, between the two regimes, and processing trade is not a big sort of deal in China.
Yeah.
Okay. Now, Lan, if you could try again on Singapore's main regime. Curious to hear about them. Thank you. Not yet. Maybe if you take your mic, if you unplug your microphone, it will from the computer as well. Let's try. No, we can't hear you.
Lan, do you mind going out of the room and coming back? Because I think maybe we can.
If you exit the conference room and then enter again. While we try to adjust Lan for the first question, Franz, regarding the income tax on imports, that also applies to imported goods or only to services?
It applies to imported goods actually. So basically, the tariff either 2.5% or 7.5% or different rate up to 10% for certain goods will be taxed with income tax. And yeah, this applies to goods, and it will be calculated based on the rate, the applicable rate, 2.5 or 7.5 or 10% times the CIF, the cost insurance rates, including all the custom duties applied when you import the goods.
Okay, thank you for the clarification. Now, Lan, again. Not yet. PT. Yeah, can't hear you. Let me propose the following then. We will jump to the second question, and we will record after the seminar, after the webinar. If it doesn't work, we will record Lan separately and then place it as well on the YouTube channel so that we can integrate the debates. Does that work for you? Does that work, Leo?
Yeah, sure, we can do this.
Okay, because we don't want to miss Singapore in our library of information about the customs regime. So, but in any event, let's try at the end of the session, we can try once again. It's awkward because it was working and then it stopped working. Okay, so let's continue with Indonesia and China, and then listen from our speakers on our second question, which is about the relationship between services inputs and goods exports. Now, let's start with Ira then in Indonesia. So how does that relationship play out in Indonesia, Ira? Thank you for joining.
Thank you. I just would like to echo Franz, that it's a privilege for us to be here. And I would like to say thank you for the invitation from the ICC Brazil. Thank you, Luiz. Thank you, Gabriella and Leonardo, for us to be able to sit with the other distinguished speakers and to discuss about the international trade as part of the webinar series conducted by ICC. Apologies for my squeaky noise, but I'll try to do my best. As you pointed out, yes, that is correct. I just being appointed as the chairwoman of the Commercial Law and Practice of Commission of the ICC in Indonesia. So it is good to be able to hear the experience of the other jurisdiction on this important discussion. As we all know, servicification in the other country shows that services are becoming more important in manufacturing activities, as well as supported, but unfortunately not in the developing countries. So the ADB research indicated that importation of services in manufacturing is fairly new, and in developing countries such as Indonesia, we still focus on the manufacturing of the exports and only small parts to the services. So the data itself shows in 2017 similar trends in Asia. So I'm interested to hear from Singapore actually, where it remains steady at roughly 17%. But in terms of value added, contribution of the services has increased. So with that introduction, I think that our understanding with the servicification refers to the process of the certain country's economy in transitioning from manufacturing to service. But Indonesia has only begun the servicifications of our economy in 2019, where the exports made up is only about 21% of the Indonesian GDP, and services only constituted 30% of all the export. So meaning service exports only constitute 7% of the Indonesian GDP, which is quite small. And as the basis of the regime for the services of input, the services of the input is not governed under any custom regime. So it is only subject to value-added tax, which is in the amount of 10%. So based on the Indonesian VAT law or value-added tax law, the following services are the one that's subject to 10% value-added tax, which is delivery of taxable services in a custom territory performed by an entrepreneur, and use of the taxable services itself from the outside the custom territory within the custom territory taxable upon the usage of such services. Is there any VAT exemption for the services input? The answer is yes. The special economic zones, free trade zones, and free ports in Indonesia already enjoy value-added tax exemption for certain services inputs from areas of Indonesia. The tax-exempt services include that toll manufacturing service, repair and maintenance services, transportation management, construction services, technology and information services, R&D, research and development, rent of transport of equipment, and interestingly is also business and management consultation, legal consultant services is part of that, and tax services. But I would like to discuss that later at the end of the discussions. Is there any VAT exemption for the services to outside of Indonesia? And yes, the value-added tax is exempted for the provision of the services to outside of the custom territory. So this includes both the export of services to other countries and also provision of services to free trade zones or free ports, as I mentioned earlier. So the tax exemptions applies the same things which I mentioned earlier as well, the list of the services. And let's say that, is there services outside Indonesia, if we perform services outside of Indonesia, whether that is also tax exempt if the usage of the services workers outside of Indonesian territory. Just take one of the example. If we are hiring the financial service firm in the United States to issue bonds in the New York Stock Exchange, that would be tax exempted. However, if we are hiring a marketing consultant in Singapore, for example, to analyze marketing strategies in Indonesia for the Indonesian company and to be used in the Indonesian territory, then it would be subject to value-added tax, which is in the amount of 10%. Is there, the next that we would like to discuss, is there any discrimination of custom policies to service inputs compared to good inputs? In terms of the discrimination, goods are clearly more heavily regulated, as what Frans mentioned earlier. Import of heavily regulated, more fiscal barriers. Import of goods is subject not only to value-added tax, but also to import income tax, import duties, excise, luxury tax, while services are only subject to value-added tax, which is 10%. We hope that, I think servicifications is quite new and nothing to, I think that we are just started Indonesia as one of the Indonesian developing countries. And I think that my explanation is only short as it is. It's only apply the value-added tax and nothing more. I think that's only from the Indonesia. Thanks, Luiz.
Thank you so much, Ira. That was useful. And as far as I could understand, if I understood correctly, there are certain tax exemptions in customs regimes, such as bonded regimes for services, which is what we were sort of aiming to find. Okay, thank you. I think we can try Lan again. Let's see if it works. If it doesn't work, then we move on to Dai to discuss the relationship between customs regimes and services in China. Lan, please. Yeah, can you?
Still not working.
Okay, well, as I said, let's record Lan at the end of the session separately, and then we will also make it available because we want you to be part of our discussion and provide your input. Mr. Dai, how about China?
Hello, can you hear me? Yeah. Hello?
Yes, we hear you.
Yes.
Oh, yeah. For the service, the service for export in China, that maybe I believe that it's not maybe supervised under the customs bureaus. Instead, for the odd service, the export service, that maybe it will be supervised and management by the tax bureaus instead. And in China, that if you provide a service to overseas clients, we could enjoy the tax refund, and that will be a VAT refund from the tax bureaus, and the VAT refund rate is about 6%, compared with the VAT refund for the goods. It will be relatively lower. And the other issue that if we provide service to the overseas, and if we got to collect the payments from the overseas, for example, from Indonesia or from the other countries, that the companies may have to. It's inevitable that we will face something about we call the withholding tax from the income tax regions that it will be considered by the companies. Currently, that we know for some services that it will have a very close connections for the goods. For example, we export a merchandise to overseas, and maybe we will then provide a serious after-sales service for the customers who buy the goods. And there is and the tax optimization plannings for such service or business modes that the companies may consider that they will divide maybe or allocate some the value of the service to combine into the goods value, and then they export such goods value to the customers, and to enjoy a bit higher the VAT refund from the customs bureaus. And but unfortunately, to some extent or from some perspectives, such so-called the taxation optimization planning may have some risks for the violations to maybe to get a bit higher the VAT refund that illegally. This is something the customs and the tax bureaus they concerns, and we know that the China customs they conduct some audits on such issues and have some findings, and then refer the case to the tax bureaus for further investigations, and allege that the clients maybe or the companies they are willfully to maybe get an illicit tax refund from the customs from the authorities. And for more issues regarding the service export and related to the export, I think there's not such more topics in China, because in China the service for export maybe relatively maybe simple like that. Yeah.
Okay, thank you. I think Lan joined by phone. Can we try once more?
Hello?
Yes, we can hear
Hello?
you. Very good.
Great. Finally.
Yeah.
Finally, you can hear me.
So
thank you so much.
Why don't we tackle first the general description of the customs regimes, and then you address the services relationship before we discuss all of us.
Okay, sure, no problem. First of all, thank you, Luiz. Thank you, ICC Brazil, for inviting me to speak at the webinar. And I'm sorry that there's some unexpected issues, and which I don't know why. But fortunately for me, it's not complicated to explain to everyone the customs regimes in Singapore. So basically, in general, Singapore focuses more on attracting regional distribution activities, where Singapore activities are limited to repacking, bulk breaking, etc., rather than manufacturing, as everyone knows that Singapore is very small. And as a background, Singapore is largely duty-free, even though it does levy two types of duties, excise and customs duties. Excise duty, a tax on import or domestic manufacture, is charged on motor vehicles, petroleum, tobacco products, and alcohol. Customs duty, a tax on import, is charged on only certain categories of beer. So the next material tax on import for export structures will then be import GST, which taxes on the import of a product into Singapore. Generally, a 7% tax on the CIF value. CIF is the cost, insurance, and the freight. Import GST might only be a cash flow tax, because you may be able to claim import GST collected when you subsequently sell the items, subject to meeting claim conditions. Now to the answer question 1 specifically. When we speak about customs regimes to promote manufacturing for export, various schemes are present to either help with duty suspension or GST suspension, or both. When items are shipped into Singapore, they are usually in a free trade zone before being brought out to customs territory. Bringing items into a free trade zone and then out of Singapore do not attract duty or import GST at all. To import goods into Singapore, you are required to make a declaration to Singapore Customs. Both GST and duty are payable for dutiable goods if these goods are imported for local consumption. When goods are moved from free trade zone or entry point into a customs licensed premises, such as the zero GST warehouses or licensed warehouses, duty and or GST will be suspended as long as the goods are stored in the licensed premises. So for non-dutiable goods, they are usually stored in zero GST warehouses. In those warehouses, GST are not payable. But in zero GST houses, generally value-adding operations intended to make the imported goods ready for the next link in the supply chain are permitted within the zero GST warehouse, as long as they do not change the original characteristics of the goods. Licensees are required to seek approval before carrying out any operations. So example of permitted operations are repacking where the total quantities of zero GST goods are not changed, and repacking, including mixing, sorting, grading, labeling, stamping, etc., for distribution or sale. In the licensed warehouses, it is allowed, which allows approved companies to store imported dutiable goods, namely liquor, tobacco, motor vehicles, petroleum, and biodiesel blends for an indefinite period of time in a designated area licensed by Singapore Customs, with the GST suspended. Duty and GST will be payable when these goods are removed from the licensed warehouse for local use or consumption. Duty and the GST are not payable when these goods are removed for export, or when supply or sale of these goods takes place while they are in the warehouse. So the direct imports, for the direct import, duty and or GST are payable if goods are released directly for local circulation. But duty and or GST are not payable for goods granted duty exemption or GST relief, or those imported under the following schemes, like temporary import scheme, major exporter scheme, approved import GST suspension scheme, and import GST deferment scheme. So for the temporary import scheme, which is designed to allow traders to temporarily import goods for approved purposes up to a maximum of 6 months, with suspension of goods and services tax, GST, and duty, which is if it is applicable, or temporarily export GST and or duty paid goods for approved purposes and re-import the same goods without GST and duty if it is applicable. And goods that are temporarily imported into Singapore should not be subject to any manipulation such that it will change the form or function of the goods. In the event there is a change, GST will be payable on the goods. So for the major exporter scheme, which is designed to alleviate the cash flow of companies that re-export a substantial amount of their imports, under normal rules, the businesses have to pay GST upfront on imports and subsequently obtain a refund from IRAS after submission of the GST returns. On the major exporter scheme, approved companies can enjoy GST suspension for non-dutiable goods imported into Singapore and on goods removed from a zero GST warehouse. Approved import GST suspension scheme is designed to alleviate the cash flow of businesses in the aerospace industry, including international airlines, companies in the maintenance, repair and overhaul industry, original equipment manufacturers, and distributors of qualified aircraft parts. This scheme will allow approved goods and services tax registered businesses in the aerospace industry to import goods into Singapore with GST suspended and remove qualified aircraft parts from the airport logistics park of Singapore or other free trade zones with GST suspended. Also, import GST deferment schemes is designed to alleviate the cash flow of taxable traders by deferring the importer's goods and services tax payments at the point of import. The approved contract manufacturer and the trader scheme is for contract manufacturers and traders to be relieved of the need to account for GST on value-added activities supplied to non-GST registered overseas customers or overseas persons who are registered under the overseas vendor registration regime as a pay-only person. So basically, these are the general introduction of Singapore customer regimes. So I think it's quite straightforward and comparatively simple.
Thank you, Lan. And how about the relationship between services and goods that are processed for export in Singapore?
Right. Okay. In Singapore, certain GST on certain services can be zero rated. Services are considered international services which are zero rated if they fall within the provision under the GST Act. Depending on the nature of the services, the company may be required to determine the customer's belonging status. Basically, whether the customer is a local or an overseas entity before the company's supply of services can be zero rated. So the international service includes service related to goods for export and goods moving outside Singapore. So the qualifying criteria to zero rate, the services must be directly in connection with goods for export and supplied to an overseas customer at the time the services are performed. There must be definite and immediate intention for export at the time the services are performed. In order for the service provider to zero rate its supply, to establish definite and immediate intention for export, the service provider must satisfy the following requirements. Service provider must obtain a written confirmation from the overseas customer that the good will be exported after completion of the services and the expected date of export. And the service provider has up to 6 days from the completion of service to ensure goods are exported and obtain the required export documents. Service provider need not be the exporter of the goods. If service provider is the intermediary service provider, meaning that after it has completed its service, it delivers the goods to another service provider of its overseas customer for further value-added services before the goods are exported. The first service provider cannot zero rate its services to its overseas customer unless it is certain that the goods will be exported. So the service provider must obtain written confirmation and the goods will be exported within 60 days as well if they want to zero rate their service. So that is relationship between service input and export.
Okay. Thank you very much, Lan, for your effort to participate. And I think it paid off because not only the presentation was very clear, but also I think Singapore, at least, I mean, from a general common sense perspective, seems a very advanced services economy. So very interesting to hear from the Singapore's perspective that you have basically if I understand correctly, provided that you're sure that the goods are exported, that means you have, I mean, you exempt or defer or whatever, reduce the tax rate on the services that are applied to those goods, which is, I think, the basic idea that triggered this webinar series. At least to us, just to put our discussions into context in Brazil, services that are embedded into exported goods, even if there is a special customs regimes applicable to the inputs in the nature of goods, the services themselves will pay or be levied taxes on, and those taxes will accumulate down the chain, therefore increasing either the cost or both, or the price of goods that Brazil exports. So our idea, since that is a very heavy burden on business, is to understand how other countries would tackle those questions. And it seems to us that in Indonesia, there are alternatives to alleviate the taxation on services, provided that you're in a special regime. In China, although the relationship is not that clear, you have an internationally, at least, recognized favorable sort of general trade regime towards exports. And then in Singapore, it seems like you address the issues in your tax, sort of general tax legislation, rather than the customs regimes themselves, if I understood correctly. So if you could, the three of you, because I mentioned all of your countries, just confirm that this understanding looks reasonable. Of course, I'm not a specialist in each of the countries' regimes, so it's just my general take on the questions, and then we move on to a sort of broader discussion. I also, before I give you the floor, I want to encourage the audience. If you have any questions, feel free to ask them, and then we can make our session more engaging. So just if you have any comments on what I just said. Feel free to jump in.
I think from just one, Luiz, I think from the explanations from Ms. Ira Eddymurthy, basically in Indonesia, exemptions for VAT on services is not only in a special, like a free trade zone or special economic zone, it also applies throughout all over Indonesia, but there are certain specific category of services applied to this special designated zone as well as outside this designated zone. Yeah.
Okay.
So for example, like us, we have an office in Jakarta, which is not a special designated zone, and we are a law firm. So if we providing services outside Indonesia, so basically, in theory, it should be free from 10% VAT, because we are one of the services eligible for this non-VAT. Yeah.
To us, at least, there is this sort of basic distinction, although the situations, they become murky at some point. If you export the service directly abroad, then it seems that most countries will exempt your VAT. But when you're providing the service to domestic, so to speak, production of a good for export, then that service is not exempt. Even though, and that's the idea, the service really is going to be packed onto a good, and the good itself is exempt. So because of the distinction between services and goods, we take it for granted that the services in most cases are taxed, and that's not an issue. But in international trade, the goods themselves will not be taxed. So that distinction for us, which is basic at the beginning, it becomes sort of artificial, because we are placing a burden on the exported good in the end by taxing the service that's going to be embedded or embodied in that good. So I think your comment also brings back that distinction. The same with us. I mean, if we export a legal service directly, there are certain advantages comparing to providing the same service to a manufacturer that, say, exports 100% of its production. Now, in the end, the distinction becomes artificial if you think of it in terms of the competitiveness of the good to be exported. If Lan has any comment or Dai?
No, really, I think your understanding is correct on Singapore side. Basically, service provider, if they expect the goods will be exported and within 60 days, they can provide the service at a zero rate of on the GST.
Okay. Leo, if we do not have any questions from the audience, I have a question to each of the speakers. Is there data on the usage of the special customs regimes in your countries? Is that data normally made available by customs, or is that data not available? Because I trying to think from a business perspective. One thing that is very useful when you're prospecting foreign markets or possible locations for foreign investment, you want to look at those basic figures. I don't know if that is made available in each of your countries. My understanding, based on what we have learned so far in this series, is that general import data is normally available, but specific import data for customs regimes is harder to find. So Dai, is it available on China Statistics or some website, that kind of information? Do you know?
The JC's website will publish some data for the import and export data for China in general. But in the past, the Chinese customs may be published by petition for some specific data, for example, for certain industries. But after 2018, the customs are no longer provide such data anymore. Yeah.
Okay, thank you. Lan?
Yes, hello. So for such kind of data, I think it's available on the website of the Singapore customer.
Okay, thank you. And then Indonesia, either of you.
Yeah, I think that on the Indonesia, that data available at because each of the government institution has their own website and should be available at the custom as well as the Director General of the Ministry of Trade for the importation and the excise. But on the tax, I do not believe that there is any specifications under the Director General of Taxes about the required information.
Okay. Thank you very much. I don't know if any of you would like to raise questions for us, among us. If not, I want to leave you a couple of minutes for final comments or just to say goodbye, if you will. Okay, so let's hear from Dai first, your final remarks, then Lan, and then Frans and Ira.
Yeah, let me say about the final remarks. Yeah, okay. Yeah, I think for China, we have a very specific the laws and the regulations that applies specifically for we call the export for the manufacturing, or we call it the processing trade. But it will be, to be frankly, in some to some extent, that the process trade in China for some maybe or how to say, maybe it will be for example more practice issues than for lawful issues, because many local practice maybe that it is not maybe clearly or specifically maybe regulated by the customs regulations, but in the different customs districts, they will have some local practice. Even though after the customs centralize the management on many other issues, for example, the declarations on HS code or the valuation issues, but for the processing trade issues, the local customs may still have some discretions on the management, and it will take a very long term to maybe united under one system. And from 2018, the Chinese customers maybe they would like to introduce new customs management systems. We called it like a golden customs phase 2, and a new customs declaration forms for the bonded goods are also introduced for the bonded goods and the bonded materials. The declarations, it will called a bonded declared sheet for the bonded goods materials. But we understand that maybe it will take a very long term to make make the China's management on the bonded goods or the bonded materials for the export will be maybe have a significant change after maybe in the couple of years or the coming years later. Yeah.
Thank you so much, Dai,
hello,
for participating. Yeah, Lan, please.
Yeah, okay, thank you. So my final remark is, as everyone knows that Singapore, as a low tax country, is very business friendly. So fortunately for our lawyers, that the customs regime here is simple and straightforward, and the system is very transparent. So whenever we need the information on the customer, on the duty, on the tax, we can always check the website of the Singapore Customs and the IRAS, Singapore Inland Revenue Authority of Singapore. So yeah, that's I think it's quite straightforward.
Thank you very much. I don't know who will start at IRA or France, but feel free to organize.
Let me start with the services here. From Indonesia, there is a hope in servicifications for the Indonesian economy, since some studies suggest that service inputs improves firms' export capabilities, especially in the high skill intensive industries. And with the above reasons, it may be a good idea for Indonesia to adapt servicification trend implemented but of course that needs to be supported by all the institutions of the government, from the financial and fiscal policy to the manpower policy, training of the employees, education policy for ensuring the competitiveness of the Indonesian service provisions. And more important thing, as the digital economy has grown, so increasing the value of output in many industries has become even more challenging, especially in this pandemic circumstances. And it would be good to really grow this servicifications trend with the support of the government. Thank you.
Thank you very much. You're Franz.
I don't have nothing to add actually. Ms. Ira Eddymurthy already covered everything. So I just want to thank you, Luiz. Thanks again, ICC Brazil, everyone who invited us on this to participate. The final remark is just welcome to Indonesia to invest your money. We welcome you all. Just invest your money here. And we are more than happy to assist you.
Thank you all. very much for joining us. Thank you, Ira and Franz from Indonesia, Lan from Singapore, and Dai Menghao from Shanghai. It's been a pleasure to discuss that sometimes difficult, but also I think very important topic with you. I think we are, as I mentioned before, we are building a library sort of information and knowledge on major economies, countries, customs regimes, and the relationship between those regimes and services inputs. So I would like to invite everyone to check ICC Brasil's YouTube channel, where by now we have 3 webinars on this topic, covering a variety of large economies, Argentina, Mexico, the United States, South Africa, Russia, India, now China, Singapore, and Indonesia. And I look forward to seeing you again. We plan on having a final event for the series yet, and you will hear from us soon. So thank you all very much. Have a good evening in Asia and a good day in Brazil. Bye.
Thank you.
Thank you.
Bye-bye. Thank you.
Thank
Stay
you.
safe.
Bye.